Hi, Hector Quiroga here with the Quiroga Law Office. Today, I'd like to talk to you about mediation and the role that mediation plays on a dissolution action and an action for divorce here in Spokane County. Now, mediation is highly encouraged by the courts. It should be a standard procedure that we have to go through before we go through final trial. Now, mediation is required under Spokane County rules when there is a dissolution that involves children. So if there are kids, you have to go to mediation. If you don't have children of the marriage, then you don't have to go to mediation. Now, this is precisely what this little video is about. You should consider going to mediation on both scenarios. The reason for that is it will take care of a lot of issues. Now, sometimes the parties are very polarized. They are completely on opposite sides, and they are there is a lot of feelings and hurt, and they're sort of at opposite ends of the spectrum, and they feel really upset, and they don't want to see the other person. They don't want to get through that process. Mediation then could alleviate a little bit of that, and then allow the parties to move on and work hard to get to the important points. What is it that we're going to divide? How are we going to split our time with the children? How are we going to have a parenting plan that works? What kind of schedule we're going to follow? Who's going to take the tax exemption? That type of thing. But before you get there, you have to do a little bit of that. Now, in my practice, I make it a step in the process to reach out to the other side to see if this is something we can do. Sometimes the parties are so amicable that between the two lawyers they can come to an agreement, even avoiding the cost of having to go to mediation, or at least I can settle certain points with the other side before we go to mediation. That way, at mediation, the only thing we have at stake is or are those points that are not in agreement. And I like to see this as a funnel, right? We start with a petition that has basically no agreement. We have a proposed agreement what we would like to see, but there's not anything settled. Then we move through the process, and we either have temporary orders, and then we have certain talk to the other side to see where we agree to, and maybe we can closer to an agreement. And then if that doesn't work, then we actually go to an actual mediation that brings it closer, and if that doesn't work, then we end up at trial. Trial is very expensive, and so we'll try to hopefully do that. I would say most things do settle before then, and that's good because trial is not only expensive, but it's extremely stressful, and is a big impact on the party's life. You got to call witnesses, you have to be available for the court. There's a lot of things that have to happen before you get to trial prep, interrogatories, depositions perhaps. So it's kind of a difficult thing, but it's important for us to know that there is a process to kind of settle those things out. I think one of the worst things that you can do is end up at trial with nothing agreed upon, partly because a trial judge is going to look at this position and say, boy, you were unable to even come in agreement to one single thing, and that usually reflects poorly in one of the parties, or both parties really, and sometimes even the lawyers. So it's important to kind of funnel that down and get to that. Mediation can help you. There is many outfits in Spokane who can help you with mediation. Mediators here that are certified mediators that can help you with that. It's important you go to a mediator that understands family law. If you don't, you could end up in a situation in which whatever you agree to, whatever agreement you come to, may not be enforceable. It may not be fully executable in a court of law, and that's really what you want. When you go to mediation, you usually come out, if there is an agreement of some sort, with something called a CR 2.8 agreement. A CR is for Civil Rule 2A, which basically states this is an agreement by the parties. They did it under their own will. They were not under the influence of alcohol and or any other substance, and they do this under free will, and they do this because they think it's in the best interest. There's some language required, and then they come into that agreement, and that agreement will be fully enforceable at a court, so the parties can change their mind after this is entered into. So Do you have to have a lawyer to go to mediation? Sometimes it's very again, if you have big issues like retirement accounts, perhaps sale of real estate, things like that. There might be a maintenance petition. So those things need to be perhaps look a little more detailed. There's a military divorce piece that probably needs to be looked at. But there are certain divorces that are shorter term and may not have a lot of assets, or they have some assets and some debts. You could mediate them on yourselves, among yourselves. That's also a possibility. However, as always, legal advice is highly encouraged. So that's what we tell you. But do think about mediation, because that is a good way to resolve the matter quicker and in a cheaper way. If you have any questions about mediation, if you'd like to have representation or use dissolution action, or if you have questions about what you're going to face, give us a call. My name is Hector Quiroga at the Quiroga Law Office, 509-927-3840. I am located here in the Valley, so again, 509-927-3840. Thank you.